7/10/22 and preliminary order has been also passed. It may kindly be listed on 6/12.
Listed for what?
For orders on bail.
Check it up what has happened. You give her the number.
Somebody will be.
Me update, my lord. I bet my child number 3, my lord. Only take up the matter before vacation, my lord.
No, we'll do it now or after vacation. It is not convenient for us.
My lord.
You do it today or we'll do it after
As
vacation.
you lord, after vacation, my lord.
All right. On the request of Mr. A. Ali, Learned Counsel,
Ad Ali, lord.
R. Ali, Learned Counsel appearing for the applicant stroke appellant. This matter stands adjourned for 3 weeks. Please
I
record.
remember.
Lordship, I'd like to mention item number 6, your lordship. Can this matter kindly be taken up on a different date, your lordship?
You are appearing for whom?
Mr. D. Gogoi.
As prayed for by Learned Counsel for the appellant, hearing of this appeal is adjourned for 3 weeks. List accordingly.
Much obliged.
Daily list for orders, item 1.
Yeah, please, your lordship. It's been ordered to apprise this honorable court. The present physical condition of the accused, lordship, we filed one additional affidavit yesterday, lordship. Is on record or not, lordship?
Just a minute. Please take your seat.
Lordship.
Yes. So what has happened? 23rd, your client went to Nemcare.
Lordship.
Then what
Lordship,
happened?
some medical checkups were done, lordship.
Hmm.
And I have filed one affidavit yesterday, lordship, to bring on record his complications.
You have received copy.
Lordship.
The affidavit is not on record. So we'll have it.
Can it be on Monday, lordship? It may be taken on record, because on 8th again, he has been called for, lordship. It can be on.
No, what order do you want right now?
Lordship, I am pressing for an interim bail, lordship, because his condition, lordship, he needs some operation, lordship. Again, he will surrender, lordship, immediately thereafter, as he has done earlier, lordship.
On 8th, he has been called for what purpose?
For angiography, lordship.
Angiography.
That is, there is a stain in his that has to be removed, only then he can undergo the operation.
You got a copy of the affidavit. You obtain instruction, we'll have it on 6th.
Can it be, lordship, on 7th, lordship?
7th.
6th, I have some personal difficulty.
All right. Heard Mr. A. Bhattacharya, Learned Counsel appearing for the applicant who submits that after the medical checkup of his client held on 23/11/2022, a report is now available and the same has been brought on record by filing an affidavit on yesterday's date you given, 30 November 2022. First of Ms. Bhuya has confirmed receipt of the Ms. Bhuya Learned APP Assam has confirmed receipt of the affidavit. First of, however, the affidavit is not on record. In view of the above, registry to tag the affidavit with the record of this case and list the matter again on 7/12/2022 for orders. In the meantime, the Learned APP Assam may obtain necessary instructions.
Development.
For hearing, item two. Parthard,
A part matter is there, call that first.
supplementary list, item seven.
On the other day, Lordship, my learned senior friend took time to see whether there is some judgment regarding acquittal of the accused, whether this appellate court can convert into conviction or not. Regarding this, Lordship, just before my learned senior friend starts, I have already submitted one judgment of Honorable Apex Court, Appa Saheb and another. That is 2007, 9 SCT 721. That issue is already settled by Honorable Apex Court, Lordship. 2007, 9 SCC. Appa Saheb. In paragraph 12, it is stated.
Is it on record?
Yes,
2007?
2007.
It's not there. Do you have an extra copy?
I had checked it, it was there in the file also. Yes. I have
Oh,
extra
maybe
copy.
it is here, yes, yes, it's here. Yes.
Paragraph 12 also.
Hmm.
On this issue.
Yes,
Mary. The learned counsel for the appellant has also submitted that there is absolutely no evidence, either direct or circumstantial, to show that Bhima Bhai committed suicide. He has submitted that the insecticide thimet is extensively used by the farmers for preservation of crops, and crops and is kept stored in their houses. And it could be a case where thimet accidentally got mixed with some food items and was consumed by Bhima Bhai. It is thus been submitted that no offense under section 306 IPC is made out against the appellants. We do not consider it necessary to examine this question. As already stated, the appellants were also charged under section 498A and 306 read with section 34 IPC, but were acquitted of the said charges by the learned session judge, which order has attained finality for the reason that the state did not prefer appeal against the same. The appeal before the High Court and also in this court has been preferred by the appellant challenging their conviction under section 304B, read with section 34 IPC. It has been held in state of AP versus Sadi Narayana, and that section 423 1B Roman 1 of the Code of Criminal Procedure, which corresponds to section 386B1 of the Code of Criminal Procedure 1973, is clearly confined to cases of appeals preferred against orders of conviction and sentence. The powers conferred by this clause cannot be exercised for the purpose of reversing an order of acquittal passed in favor of a party in respect of an offense charge, in dealing with an appeal preferred by him against the order of conviction in respect of another offense charge and found true. Therefore, we have refrained from expressing any opinion as to whether the appellants could be held guilty of having committed the offense under section 498A or 306 IPC on the basis of evidence available on record, as their acquittal under the aforesaid charges has attained finality and cannot be reversed in the appeal filed by the appellant challenging their conviction under section 304B IPC. In view of the above discussion, in view of the discussion made above, the appeal is allowed. The judgment which is relied on by this, by the honorable appellate court that I am handing over to your lordship. Here, exactly the state issue was there. Initially, the appellant was tried under section 302 and 392 in the judgment which I have just referred to your lordship. And the trial court acquitted him from charges under section 302. Thereafter, he preferred jail appeal for 2 years sentence under section 392, and the High Court said that there is no material to convict him under section 392, but there are material to show that he is involved in section 302. So he was again acquitted under section 392, and the case was remanded back for retrial. Thereafter, the matter went to Supreme Court, and Supreme Court said once it is the acquittal order is there, that has not been challenged by the state. Therefore, that order attains finality. And similarly, where under section 392, when the High Court acquitted him, that order is also not challenged. So ultimately, he was acquitted from both the charges. So paragraph 1 is the question which is before your lordship now.
Yes,
The short question and interesting question which arises for our decision in the present appeal is in respect of the powers of the High Court in disposing of appeals under section 423(1)(b) of the Code of Criminal Procedure. In dealing with an appeal preferred by a convicted person against the order of conviction and sentence imposed on him by the trial court, can the High Court, in exercise of its appellate power under section 423(1)(b), reverse the finding of acquittal recorded by the trial court in favor of the appellant in respect of an offense which is directly not the subject matter of the appeal? On this question, there has been a difference of opinion amongst our High Courts, and it appears from the reported decisions that in the same High Court, sometimes conflicting views have been expressed on the point. So these various provisions were discussed, and the finding of the court was
yes,
so ultimately paragraph 18 is the finding. Okay.
Yes.
So here also in our case, Lordship, 304 is not, B is not challenged by the state. So that remains, Lordship, and that findings attain finality, Lordship.
Lordship on the, when the law upon your lordship has gone entirely to the evidence on record, Lordship, here my reciprocal submission is that, your first point is the first, my argument would be your lordship may refer the matter back to the learned trial court to hear the matter afresh, your lordship, because evidences are there, and thereafter decide, take a decision after taking into account the evidence and record of fresh, your lordship. At one point, your lordship, one aspect, your lordship. And second, your lordship, there's error on the part of the learned trial court in framing charge, because no charge under 34 has been made out. So in this regard, I have to refer, lordship, section 215 of the Code of Criminal Procedure. As well as 464 of the Code of Criminal Procedure.
Section 2.
215 as well as 464, your lordship. 215 first. Effects of errors. No error in stating either the offense or the particulars required to be stated in the charge, and no omission to state the offense or those particulars shall be regarded at any stage of the case as material unless the accused was in fact misled by such error or omission and it has occasioned a failure of justice. In the instant case, no lordship, no plea has been taken by them. There was a failure of justice. So your lordship may take into account that part. And apart from that, 464 of the Code of Criminal Procedure. Effect of omission to frame or absence of an error in charge. No finding, sentence, or order by a court of competent jurisdiction shall be deemed to be invalid merely on the ground that no charges framed or on the ground of any error, omission, or irregularity in the charge, including any misjoinder of charges, unless in the opinion of the Court of Appeal, confirmation or revision, a failure of justice has in fact been occasioned thereby. If the Court of Appeal confirmation or revision is of the opinion that a failure of justice has in fact been occasioned, it may, in the case of an omission to frame a charge, order that a charge be framed and that a trial be recommended from the point immediately after the framing of the charge. In the case of an error, omission, or irregularity in the charge, direct a new trial to be had upon a charge framed in whatever manner it thinks fit, provided that if the court is of the opinion that the facts of the case are so that no valid charge could be preferred against the accused in respect of the facts proved, it shall cause the conviction. So your lordship, at this stage also your lordship may do so. And apart from that, your lordship, I have got certain decisions of the Honorable Supreme Court. As reported in your lordship, 2004 5 SCC 334 minus. Para 17. May I read it, Constable? Dalbir Singh versus State of UP. Para 17. There are a catena of decisions of this court on the same lines. It is not necessary to burden this judgment making reference to each one of them. Therefore, in view of section 464 CRPC, it is possible for the appellate or revision court to convict an accused for an offense for which no charge was framed, unless the court is of the opinion that a failure of justice would in fact occasion. In order to judge whether a failure of justice has been occasioned, it will be relevant to examine whether the accused was aware of the basic ingredients of the offense for which he is being convicted, and whether the main facts sought to be established against him were explained to him clearly, and whether he got a fair chance to defend himself. We are therefore of the opinion that Sankaraboina Srinu was not correctly decided and it purported to lay down a principle of law that where the accused is charged under 302 IPC, he cannot be convicted for the offense in the 306 IPC. So here also, Your Lordship, during at the stage of hearing in the Supreme Court, Lordship, the Honorable Court held that at this stage also in the appellate court also it can do so, Your Lordship. Well, the charges not framed under section 34, Your Lordship may do so instead of referring back the matter back to the learned trial court, Your Lordship may decide here, Your Lordship. And one judgment, 2003, 1 SC 217, my Lord, para 22 and 23. Now, para 22, now mere omission or defect in framing the charge does not disable the criminal court from convicting the accused for the offense which is found to have been proved on the evidence on record. The Code of Criminal Procedure has ample provisions to meet a situation like the present one. From the statement of charge framed under section 304B and the alternative section 498 IPC, it is clear that all facts and ingredients of framing charge for offense under section 306 IPC existed in the case. The mere omission on the part of the trial judge to mention section 306 IPC with section 498 IPC does not preclude the court from convicting the accused for the said offense when found proved in the alternate charge framed under section 498 IPC. It has been clearly mentioned that the accused subjected to deceased to such cruelty and harassment as to drive her to commit suicide. The provision of section 221 is to take care of such a situation and safeguard the powers of criminal court to convict an accused for an offense with which he is not charged, although on facts found in evidence he could have been charged for such an offense. The provisions of subsection 2 of 221 read with section 1 of the said section can be taken aid of in convicting the sentence accused one of offense, abatement of suicide under 306 along with that instead section 498A. Section 215 CRPC allows the criminal court to ignore any error.
Just a minute.
My lord.
You have not given a book list.
Lordships. At 10:30 I have taken. And here I agree with my learned friends, since learned trial court has acquitted the this appellants from the charge, since there is no appeal against acquittal, at this stage lordship may not interfere with the order of acquittal, your lordship. But regarding the Veda 34, if your lordship finds there are materials to convict the accused person, 302 with 34.
Show us what is the material which is there to convict the accused person?
34, your lordship, regarding vicarious liability, my lord. Lordship, they have the common intention because the demand of dowry was there. Every member of the family tortured the victim, your lordship.
Where is that evidence? Every member tortured.
Lordship, evidence of PW1, PW2, PW3 and 5. There were harassment, your lordship, the victim was lordship, was given demand of dowry every now and then.
You are not arguing now under 304B. Correct?
And 304B because
304B is out.
gone.
So there is a demand for dowry and there was torture. That doesn't make out a charge under.
And their cruelty was also there because your lordship during the lifetime of, although their law permit, my lord, their law permits, but during the lifetime of the deceased, then he remarried, which she didn't like it. And this victim, he died in a mysterious circumstances. The lordship in the midnight, your lordship, before 3 o'clock, the incident taken place.
Are these enough for you, according to you, to prove a charge?
Under 302.
302 and that too of 3 appellants. Is it
And
permissible to
the
presume?
father of the accused Karimul and the Karimul himself, they are lordship directly involved. Although as regards demands of dowry, your lordship.
That's correct.
And she was not treated
Demands of dowry
properly.
is there.
But once that charge
What about-
goes, my lord,
What
that
about other things? That by itself, in 302, that is just a link in the chain.
yes, my
If it was 304B, then it was a completely different chapter. But
lordship.
The
So, your
same
lord-
evidence
my
under
lord.
302 will be
Yes.
just one link in the chain.
Lordship, proper course would be because at the face of it, the lordship case of 304.
Pull up the IO and
Lordship.
prosecution. This is the only answer to this.
Lordship, your
They did
lordship,
not know how to conduct the case.
lordship may remand this matter back. It's not a case of acquittal, your lordship.
No, but we'll observe that it's a very, very poor show by the investigating agency and the prosecution. People who did not know how to handle these cases were handling this case.
Or
No,
alternate, my alternate submission,
Hmm.
because the ingredients are there, 498A, only in 3 years that is there, your lordship. It can it be, your lordship, may take into account that factor? Conviction under 498A. Lesser sentence your lordship may give, although like,
Let us see the IPC, please.
498 is also acquitted.
There is acquitted.
Acquitted.
there's permissible, no?
Yes, yes.
Oh.
But the prosecution has failed to bring home the charges under section 498 and 304.
Then your lordship can.
Hmm. Who was the judge who had passed this order? Is he in service? Chakravarti. Entire position, no? Police Chakravarti. Precious. What else you have to say?
Lordship matter may be remanded back to take a decision afresh after hearing the.
You are saying there should be a retrial.
No, not retrial.
Then
Lordship, the charges were framed, your lordship, and thereafter, lordship, evidence was on record. At the stage of argument, your lordship, they may be hard afresh and take a decision.
but why?
afresh.
We'll do it here. You give us the evidence. Why the trial court should do it? We'll do it here. This is appellate court. Trial court only necessity is when there is a need to adduce further evidence. That you are not asking for. So based on the evidence, if conviction is
No,
possible.
but your lordships, because the acquittal is given.
No, Miss Bhuya, you don't mix up these two.
No, your lordship.
304 is gone.
304 is gone, but
That's
still
gone forever. That's gone forever and gone for everything else which is not connected with this court. We can't help it.
I have no submission to make, my lord.
But about 302,
302 and.
why do you want the matter should be sent back to the trial court? What is the purpose?
To
Let us
rehear,
understand your submission.
my submission is if your lordships comes to a conclusion, the 304 now it's a bill at stage, it cannot be opened
No,
up.
it's not about a conclusion. It's about if the law doesn't permit it, it cannot be done. If there is an acquittal, no appeal against acquittal, it cannot be done. And that is bolstered by the decisions of the Supreme Court.
Yes.
The state did
Then
not,
I have
state has
nothing
the
to-
option to prefer an appeal, but
Lordship.
did not do it. And insofar as 302 is concerned, there is a conviction of 3 persons. No charge framed under 34, no finding of common.
34, still your lordship may add it.
We can add it.
Yes.
Where is the evidence to come to that conclusion that there was common intent?
Common
intention.
intent to kill was there because she could not fulfill the demands of dowry. She and her family members, there was repeated demand of dowry, your lordship, cruelty meted to her. She was not treated properly. As a result of which, lordship, at midnight, she had to, I don't know whether she had committed suicide or whatever, your lordship. There's not a evidence on record that she was killed, your lordship. But she knew how to swim. The water was 1 feet of height. But it was a monsoon season, your lordship. The water of the river was full now.
See, the criminals are getting away because of absolute apathy of the state machinery. Criminals are getting away. That's beyond that, we can't say anything else.
And your lordship,
Almost all the cases are genuine cases where crime has been committed,
I know.
but the courts are left with no option but to look the other way, because the IO doesn't investigate, the prosecution doesn't know how to press a charge, which evidence, which witness to examine. Here, the relatives of the accused persons have been examined as witnesses. They gave a version which does not support the prosecution case. These people could not have been examined as witnesses. So it clearly shows that the public prosecutor has no idea how to conduct a trial in such serious matters where a 302 charge is involved. The state doesn't bother to even engage a public prosecutor who knows how to conduct a trial. This is the state of affairs.
I do agree, Your Lordship.
That's it, nothing else. We
And-
can't mutilate the law
Yes.
just to cover up the misdeeds of or wrongdoings of someone at some stage. The law has to go on its own course. And then what happens? For a lawyer like Mr. Ahmed, he will find out the loopholes and ask for an acquittal. That's all. That's the whole business of criminal trial in this country, or at least in this state. That's the whole business. Do whatever you feel like, convict them, let them stay in jail. High Court will in any case acquit, because there is no evidence. What will the court do? But in this case, we are very unhappy with the manner in which the sessions judges dealt with it.
Yes, Your Lordship.
He is not in service, otherwise we would have recommended some action against him. Absolute cavalier fashion. The gentleman who has passed this judgment as sessions judge, atrocious to say the least. He had no idea of how to conduct, how to deal with a criminal sessions case. That's what it appears. These are fundamental things. Fundamental things. This is not even an area where there is subtlety of law involved. He convicts 3 persons under 302 without framing a charge under 34. All right. There is not even a finding that there is a common intent. Nothing. When the entire evidence is staring at the face that it's a case under 304B, he grants acquittal to the accused persons under 304B. And convicts them under 302, only 302, without showing how the chain of circumstances is established. There is nothing. She was there was some dowry demand, she came home, and one morning she was found near the pond lying dead. That's enough to establish a charge under 302. What is happening? You all should ask questions as officers of this court. Chamber, reserve judgment.
Lordship, one factor Lordship will take into account, the occurrence have taken place during midnight. No explanations. Accused persons were found at the
These are all
residence.
additional links, but where are the main links?
Missing, Your Lordship.
Where
We are
are
case
the-
of 304B, Your Lordship. I don't know why.
That's what I'm expressing my mind. If the officer was in service, we would have called him and asked him. I don't want to name the officer, but he retired last year in June. On 30th of June 2021, he retired.
What do you say, no?
Absolute poor state of affairs, even in our ranks. We'll see what Mr. Ahmed, we are very unhappy with things. So technically, even if you made out a case, we can't guarantee you anything. We'll see how we'll deal with it.
All right.
There has been too much of this technical
Yes, my
loopholes,
lord.
and this is how it is all going on. Come to the High Court and get an acquittal, because there are umpteen number of loopholes, misconducting of trials. IO is not doing anything. All right.
All right.
Mailing list item 2.
May it please your lordship. The lordship, this is an appeal from the session judge Sunitpur, whereby the accused has been convicted under 302.
He was initially charged also under 304B, but under that section, he has been acquitted. And the conviction has only been based on the dying declaration of the victim. Your Lordship, I will try to show that initially that there is a direct evidence, ocular evidence, eyewitness who saw the victim pouring the kerosene on herself. And secondly, I will try to portray that the dying declaration is suspicious and not reliable because of the direct evidence of the witness, as well as because the members of the family were present. When the families are present, your Lordship would have to see the other evidences also and not rely solely on the dying declaration. And thirdly, the dying declaration itself is contradictory, gives a statement which is possibly not believable. That I will show. Your Lordship, I will take, maybe I read the FIR first or. Page 4. It's been lodged by the grandfather of the victim.
Yes,
So and so. Humble submission is that 4 months ago, the above named accused person married my granddaughter, Smith Pompey Devi, after falling in love with her. Since after the marriage, the accused person has been torturing my granddaughter in various ways by demanding dowry. Around 7 p.m. on 21/10/2014, he again assaulted her by demanding dowry and with the intention to kill her. He poured kerosene on her and set her on fire. With the help of neighbors, my grievously injured granddaughter was taken to Tachpur Medical College. Since the injuries were of grievous nature, the doctors referred her to Guwahati Medical College and Hospital. Presently, my granddaughter is undergoing treatment at Guwahati Medical College. I therefore pray to you to take necessary action in this regard by investigation into the matter and oblige. By that time, during the investigation, the victim passed away, succumbed to the injuries. Accordingly, 302 was added. Lordship, may I read the PW1?
yes,
The Lordship, this is a vital witness because this witness stays right across the accused house where the place of occurrence was. And as per the sketch map, this house is located at a distance of around 8 meters. It's just across the road. Lordship. I know the accused present in the dock. His name is Pankosna. I know the deceased woman. She was the wife of accused Pankosnas. Accused is my neighbor. The occurrence took place about 1.5 years back. On the date of the occurrence as 8:30 p.m., my wife and I took meal, and at that time I heard Hulla in the house of Pankosna. There was quarrel between Pankosnas and his wife. As the house of the accused was just in front of my house, I saw the wife of the accused was about to leave her matrimonial house, but the accused was objecting to her leaving matrimonial house. My house is in front of the house of the accused, and it was at a distance of about 40 feet from my house. I made the statement before police in connection with this case. I stated before police that sometimes the accused and his wife quarrel with each other. I stated before police that on the date of the occurrence at about 7:50, Pompey Devi caught fire on the road, and she was crying. And I, along with Pankaj Nath and others, rushed to the place of occurrence to put out the fire. So he along with the accused, tried to actually douse the fire. At the relevant time, there was alteration, quarrel between the Pankaj Nath and his wife, deceased, Pompey Devi, over the issue of her leaving matrimonial house. Pompey Devi was coming out of her matrimonial house with oil lamp in her hand. She herself was carrying. We saw Pompey Devi caught fire when she came out on the road. I, along with Pankaj Nath and others, doused the fire. On seeing the occurrence, my wife became senseless, and then I took the wife to hospital. So I do not know the subsequent event. Your Lordship, this is a direct evidence which says she herself was carried at kerosene, and on the road, she lighted hustle in the sense because and in fact, the accused was trying to douse the fire. And other witnesses are all, they have not seen the incident and they do not stay near the house. So this evidence has to be considered vis-a-vis the dying declaration. PW2, I know the accused present in the dock. His name is Pankaj Nath. I knew this is Pompi Devi. She was the wife of the accused Pankaj Nath. The occurrence took place about 1.5 years ago back. On the day of the occurrence at about 9 p.m., I heard hulla in the village. Then I rushed to the place of occurrence. I went to the house of Pompi's mother where I saw that Pompi was lying with burn injuries on her person. Then I took to the hospital in Nekar. Your Lordship, here, after the fire was down, he was taken initially to her matrimonial, her mother's house. From there, she was taken to the hospital. It is not a fact that I stated before police that on being asked, she told me that her husband poured kerosene on her and set her on fire. It is not a fact that I have good relation with the accused. It is not a fact that I have given false evidence to save the accused from this case. I do not know Pompi Devi caught fire or sustained burn injury. How? I saw Pompi Devi lying on her mother's house, burn injury on her person. I took her to Tezpur Medical College, but I did not have any talk with her regarding the incident.
This witness was declared hostile.
Hostile. Because he says he haven't seen how she, in fact, how she was actually caught fire on her. And he saw her for the first time in her mother's house. PW3. He is the complainant and the grandfather. I am the complainant. Accused Pankaj Nath is my grandson-in-law. Deceased Pompi was my granddaughter. She got married to the accused about 5 months before her death. The occurrence took place on 21/10/14. On that day at about 8:30 p.m., my son-in-law Dilip Nath informed me over phone that my granddaughter Pompi has been set on fire by accused Pankaj Nath by pouring kerosene oil over her body. On getting information about the incident, I rushed to Tezpur Medical College as she was admitted there. I saw Pompi in the hospital and the wounds on her person were being bandaged by doctors. Then I went to the house of Dilip Nath, father of the deceased. Dilip Nath and his, so your lordship, Dilip Nath didn't come to the hospital. He was still at his home. That is only the neighbors took the victim to the hospital. Dilip Nath and his neighboring people told me that when the deceased was about to sleep, the accused poured kerosene over her body and set her on fire. Then again, I went to the hospital, and in the hospital, Pompi Devi disclosed before doctor, police, and me. So even he was present. I'm relying on this. That on the relevant that in the evening, the accused returned from the market and he was drunk. And when Pompi asked him why he had consumed liquor, he slapped her. She also stated before doctor, police, and me that when she went to sleep, the accused poured kerosene over her body and set her on fire. Doctor advised that she had sustained 90% injuries, so she should be immediately shifted to Guwahati Medical College. Then she was shifted to Guwahati Medical College. After 4 or 5 days in Guwahati Medical College, Pompi succumbed to her injuries. After the marriage, Pompi visited my house once, and she told me that the accused was demanding dowry from her. This is the only witness who is saying about dowry. There was no. In fact, her dying declaration does not say anything about dowry or there was demand of dowry. Or in fact, the father also does not say anything about it. On 22/10/14, while Pompi was still in Guwahati Medical College, I lost the Ejahar with Thelamara Police Station. Exhibit 1 is the Ejahar, Exhibit 1 is my signature. It's crossed by the defense. I got the Ejahar written at Thelamara. From my house to the place of occurrence is distance about 8 to 9 kilometers. I did not see the incident when it took place. Ejahar was written as per my statement, and it was mentioned in the Ejahar. I mentioned that the accused demanded dowry from the deceased. On getting all the information regarding involvement of the accused in the commission of the alleged offense, I filed the Ejahar. It is not a fact that I have. It is not a fact that I have written the Ejahar without knowing the actual fact of death of the deceased. It is not a fact that I have deliberately written about the demand of dowry and about pouring kerosene oil and setting fire to Pompi Devi by the accused. It is not a fact that I have falsely stated that after the marriage, Pompi came to my house and told me that the accused has demanded dowry. Police recorded statement of the deceased Pompey in the hospital, but did not obtain my signature on the said statement. When police recorded Pompey Devi's statement in the hospital, I was present on that day, but I did not lodge Ejahar on that day. It is not a fact that Pompey Devi was not in a position to speak with burn injuries. While concerned police officers recorded the statement of Pompey Devi, 2 doctors and I were present in the hospital. It is not a fact that I had given false evidence. I cannot say at exact time when I reached hospital. It is not a fact that the story of the demand of dowry, etc., has been concocted by me. Your Lordship, herein he says that in the evening, on the relevant date in the evening, the accused returned. Whereas in the dying declaration, and from other evidence it will be apparent, it is in the afternoon that he returned. So there is some contradiction in his statement. When the accused returned, because accused returned, the incident happened at midnight or in the night after dinner, but he has returned in the state of consuming alcohol only in the afternoon at 3:30, not in the evening. Further cross-examination PW3, page 15. I never visited the house of the accused. The deceased and the accused had love affair and then got married. I do not know whether the accused was immediately taken to hospital with the help of the villagers. It is not a fact that to make out a case of dowry, I have falsely stated that the accused subjected my grandfather demanding dowry. It is not a fact that the accused did not pour kerosene on the body of the deceased and set her on fire. It is not a fact that the deceased somehow caught fire herself.
Yes.
PW4 is a cousin of the victim. I know the accused present in the dock. His name is Pankaj Nath. Complainant so-and-so is known to me. I knew this is Pompey Devi. The occurrence took place about 2 years back. On the relevant date, about 7 p.m., I saw deceased Pompey Devi was burning and came running from the house of the accused. But he contradicts himself in the cross. I tried to douse the fire with my hand. On being asked as to how she caught fire, she told me that her husband poured kerosene on her body and set her on fire. Then I, along with other people gathered at the place of occurrence, took her to Tezpur Medical College Hospital in a tempo. Ross, it is not a fact that I stated before police that when I reached the place of occurrence, already fire was put out. It is not a fact that I did not state before police that I tried to douse the fire with my hand. It is not a fact that I, along with Putul Nath and others, did not take the disease to Tezpur Medical College. It is not a fact that Pompey burned herself by pouring kerosene on her body. My house is at a distance of 2 kilometers. Your Lordship, this is important because if it is at a distance of 2 kilometers, we cannot see the accused running from the house and while she was on fire from the house of the accused. I met the deceased on the road at a distance of about 1 furlong from my house. So he met the deceased on the road. If he meets in the road, he cannot see whether the victim was coming out already burned from the house. So the PW1 statement that he saw the victim pouring kerosene on herself still stays. Because his house is at a 2 kilometers and he says himself that I meet the deceased on the road. It is not a fact that my house is, here he says my house is at a distance of 2 kilometers. Again, he says it is not a fact that my house is at a distance of 2 kilometers from which I could not see the occurrence. It is not a fact that I have given false in the interest of my cousin deceased. So, Your Lordship, this evidence, I would pray that this has to be disregarded because there is contradiction and I'm not a reliable witness, being an interested witness. He is the cousin of the victim also. PW5. I know the absentee accused. I have known the informant. I knew the deceased who was the wife of the accused. The occurrence took place in the year 2015. Smith Jarna, the mother of the deceased, has telephonically informed me at night that her Dr. Pompey got burned and called me to Mukhi Medical College. Due to my eye problem, I could not come on that night, but I have attended the hospital on the next morning, and at that time, doctor has referred injured Pompey to GMC. I saw Pompey in a burned condition, and people along with a reporter had asked Pompey as to what happened, and she told that she was burned. Police has recorded my statement. It is not a fact that I have stated before the police that injured Pompey has stated that she was burned by her husband. the accused by using kerosene. So he has turned hostile, Your Lordship. He has himself stated that he has not heard the injured Pompey stating before the police that her husband, it was her husband who has poured the kerosene and burned her. The last line. Crossed by the prosecution. It is not a fact that I have stated before police that injured Pompey has stated that she was burned by her husband, the accused by using kerosene. It is not a fact that in order to save the accused, I have stated falsely before the court today, in spite of the fact that Pompey has stated the name of the accused that he burned the deceased. Crossed by that. I have not stated before police that so-and-so, the mother of the deceased, has telephonically informed me at night that her daughter Pompey was got burned and called me to so-and-so medical college. And due to my eye problem, I could not come that night, but I have attended the hospital on the next morning. And at that time, doctor had referred injured so-and-so to the GMC. I have also stated before police that I saw Pompey in burned condition, and the people along with the reporter had asked Pompey as to what happened. And then she told that she was burned. Police has recorded my statement. When I saw Pompey at Tunga Medical College, she was not in a position to talk. Rather, she was gagging. Your Lordship, this is important. I do not know as to how Pompey got burned. So, Your Lordship, the witness says that she was not in a condition where she could submit in her. She was in a sense of mind where she could submit as to what happened, the correctness of the incident that happened. PW 6. This is Pompey Devi was my daughter. Accused Pankaj Nath is my son-in-law. The occurrence took place in the year 2014. On the date of occurrence, I, along with my wife, went to the house of my daughter, the deceased, with some black dal, and we have noticed some quarrels in the house of the accused. The accused has entered into altercation with my daughter, the deceased. At that time, the accused was in a drunken condition. Then, on being asked, my daughter has stated before us that she had sent the accused for marketing with 200 rupees. But instead of marketing, the accused has spent the same and returned with drunken condition, and that is the reason of the quarrel. Your Lordship, there is no mention of dowry here. Then we went into a neighboring people, Homeshwar Nath, and told him about the incident and also requested him to see them into the matter, who assured us that they will look into the matter. Your Lordship, this statement has come for the first time. It was not stated before the IO, and he himself admits in the cross. While we were in the house of Homeshwar Nath, we heard the hulla and also heard that the accused got my daughter burned by pouring kerosene. Immediately, we came to our house and found my daughter in burned condition, and the neighbors took my daughter to medical college. On the next day, as per the advice of the doctor, she was taken to GMC Guwahati. After about 1 week, my said daughter died at GMC Guwahati. On being asked, my daughter has stated before us that the accused got her burned by pouring kerosene. On the next day of the occurrence, my father-in-law and so had filed FIR before the police station. Cross. I have not stated before police that I, along with my wife, went to the house of my daughter, the deceased, with some black dog, and we have noticed some quarrel in the house of the accused, and the accused has entered into altercation with my daughter, the deceased. And at that time, the accused was in a drunken condition. And then, on being asked, my daughter has stated before us that she had sent the accused for marketing, but instead of marketing, the accused has spent the same and returned with drunken condition. And this is the reason for the above statements are made by me for the first time before this court today. I have found my daughter in my own house in a burned condition. I have not personally seen as to how my daughter got burned. My house is at Gavaru Baligaon, situated on the eastern side of the Gavaru River. The house of the accused is at Kochgaon, on the western side of the Gavaru River. The distance between my house and the house of the accused is about 1 mile. This is important. The house of the Homeshwar Nath is at Kochgaon. Homeshwar Nath is alive. I have stated before police that I have seen my daughter in burned condition at Teshpur Medical College. Whereas in his on report. Yes. Yeah. The Lordship, in his deposition, he has stated that he came to his house, then went to the medical college, Teshpur Medical College. But whereas in his cross, he has stated that he saw his daughter first in the medical college. So there is again contradiction.
No, what is the contradiction? He came to his house and then went to the
No,
meeting.
lordship say, his statement, there is a river. The western side of the river is his house, and the eastern side of the river is the house of the accused. And Homeshwarnath house is on the west eastern side. So near about the accused house. As per his own deposition, he says after meeting his daughter in the house of the accused, he went to Homeshwarnath. And it seems he had come, the accused has come at 3:30 in the afternoon. So he must have stayed for the entire till evening or till dinner time, entire in Homeshwarnath's place. So when hearing the hulla in his deposition, he says he went to meet his daughter on the western side. Normally, if his house is on the, if the accused house in the west eastern side, and the incident has taken in front of the accused house, courtyard of the house, then he should have gone to meet his daughter there where the hulla was. He would not have gone to meet his daughter in his own house in the other side of the bank, because it seems after the fire was doused, she somehow from that place of occurrence, she went to her father's house. So how she went there, that has not come into evidence. But in a dying declaration, she says she ran. It is highly impossible that she a burned, a 90% burned person could run 1 kilometer. But be that as it may, Your Worship, so here the contradiction is that one is it is not possible his deposition because he should have gone to the place of occurrence which is nearby instead of going to the other side of the river to meet his daughter in that house. Again, in his cross, he says he saw his daughter for the first time in the medical college, not in his own house. Why I'm trying to say this, this entire thing shows that evidence is not reliable. And at last, I will show when the dying declaration is given in the presence of family members, then the surrounding circumstances has to be seen. Solely cannot just be on the basis of the dying declaration. And when the family members are giving evidence which is not reliable, keeping in mind the evidence of PW1, I will then the charge or conviction under 2302 is, I would pray for setting aside the conviction. I will show the, and as well as the father, grandfather, he is the complainant. He says, I met in the evening, whereas it was in the afternoon. And he is the only one who says, though he says, I have never visited her.
So you say the conviction is based on oral dying declaration?
Yes,
It was not recorded by anyone.
it was recorded by the police and signed by the medical officer. But she says, from the place of occurrence, after the fire was doused out, she ran 1 kilometer from the place of occurrence to the other side of the river.
So what is wrong about it?
A person who has 90% burn cannot run.
Why? Where is the basis to say that?
Basis is that the body becomes so tight because when a burned body is, it is impossible to run. The bones and the muscles becomes tight.
No, but you have to tell us, give us medical.
I will show from Modi's technology that Modi's jurisprudence that a burned body, the muscles contract, it is tight. So tight muscles who cannot relax, it is impossible to run.
No, but the muscles take some time to contract. It doesn't happen instantly. You see, the victim's statement, let us read her
Yes.
declaration first.
Yes. And this I am saying, if the PW1 evidence was not there on record, maybe everything has to be seen. The PW1 evidence has to be.
Let us first see her
Yeah.
declaration. Where is it? Page number?
Page number 54. My name is Pompi Devi. My pet name is so-and-so. I am 15 years old. Following a love affair, I eloped with Pankaj Nath, son of so-and-so in the month of Jan, and started leading a conjugal life. My parental home is at Nutun Baligaon. I have my mother, father, and elder brother. Today on 21/10, my husband Pankaj Nath went to Khelamati market. Around 3:30 p.m., he returned home in an inebriated condition. Since I raised objection to his coming, it's 3:30, Your Lordship. Since I raised objection to his coming home drunk, he slapped me. After having dinner at around 7 p.m., my husband and I went to sleep in the bed. Same bed. After I have gone to my bed, my husband poured kerosene on me, lit a mastic and set fire to the clothes I was clad in. When I caught fire, my husband fled the scene. Then the villagers came and doused the fire, whereupon I ran to my father's house. The father's house is admittedly, it's 1 mile across the river. It comes in evidence. So, and the grandfather was present. He himself admitted that he was present while the statement was given.
No, but then I ran to my father's house. Does it mean she ran towards the father's house or she ran and reached the father's house?
She reached the father's house because it was taken, it is from the evidence. She was taken to the hospital from the father's house.
So if that is there, then obviously she has reached the father's house.
Yes.
What is the problem then?
But on herself by running 1 kilometer, 1 mile,
Hmm.
it's not practically possible.
Oh, but she did it.
That's why I'm saying.
She
That's why-
ran and there is evidence to show that she was taken to the hospital from the father's
No,
house.
so does it create a suspicion? Is it possible? If it is not, it is impossible because the dying declaration was given in the presence of the grandfather who has tried to, for the first time, even the victim doesn't say there was demand of dowry, the quarrel was clear. He tries to bring into the angle of dowry. His statement also has to be seen in that context, whether he is trying to force or create a case when she herself lit the fire, because PW1 specifically says he
No,
saw.
Mr. Sharma, so this is a dying declaration which was recorded by the doctor, is it? Or
Recorded by the IO police,
Hmm.
but the doctor has signed it. So there I am not.
You're not questioning the dying
That I'm not,
declaration.
because I cannot.
But you are saying she lied in her dying declaration.
It creates a suspicion, I'm saying. When it creates a suspicion and the declaration is in the presence of a family member,
Hmm.
then the court has to see the surrounding circumstances and the evidence and the facts.
Why? Why?
Because the presence of the family member might create pressure. That is what the court says here. That is because the presence of the family member might put undue pressure or coercion on him. And in doing so, your lordship will then have to see PW1, then we'll have to see the complaint
All right, let us go back to PW1 once.
here. May I come to the last part, your lord? Last part, or your lordship, should I read the entire?
Just a minute.
Page 9, your lord.
Let us read again from the beginning.
Yes, sir.
So that,
Yes,
let's see the fine print now.
yes.
Hmm.
I know the accused present in the dock. His name is Pankaj Nath. I knew deceased Pompey Davis. She was the wife of the accused Pankaj Nath. Accused is my neighbor. The occurrence took place about 1.5 years back. On the date of occurrence at about 8:30 p.m., my wife and I took meal at that time. I heard hulla in the house of Pankaj Nath. There was quarrel between Pankaj Nath and his wife. As the house of the accused was just in front of my house, I saw the wife of the accused was about to leave her matrimonial house, but the accused was objecting to her leaving matrimonial house. Whereas in a dying declaration, she says they had slept. My house is in front of the house of the accused, and it was at a distance of about 40 feet from my house. I made the statement before the police in connection with this case. I stated before the police that sometimes the accused and his wife quarrel each other. I stated before police that on the date of the occurrence at about 7:30 p.m., Pompey Devi caught fire on the road, not from inside. She didn't come running outside with fire on her body. And she was crying, and I, along with Pankaj Nath and others, rushed to the place of occurrence to put out the fire. This is
We'll see the vernacular, what is the version, because
right.
uh,
May I just
our
complete the
translators
cross?
are also,
Then definitely we'll have to take the literal meaning from the vernacular. Cross by addition. At the relevant time, there was alteration quarrel between Pankaj Nath and his wife, deceased Pompey Devi, over the issues of a living matrimonial house. Pompey Devi was coming out of a matrimonial house with an oil kerosene lamp in her hand. She was carrying it. We saw Pompey Devi caught fire when she came out of the room. I, along with Pankaj Nath and others, doused the fire. On seeing the occurrence, my wife became senseless. Then I took my wife to hospital, so I do not know about the subsequent event.
So you see, this cross-examination of PW1 has clarified the doubt he wanted to create in chief. It appears that they saw the victim on fire when she came out on the road.
No. If your lordship says,
Ms. Bhuya, do you have the LCR?
here,
Yes, Lordship,
you-
but it's in English, evidence of PW1,
Hmm.
it's in English now,
Achha, let us, since we are on PW1, can you please read it once,
the
PW1?
whole, from the beginning.
Just the PW1
My
statement.
lord. Pranjal Nath, I know the accused present in the dock. His name is Pankaj Nath. I knew this is Pompi Devi. She was the wife of accused Pankaj Nath. Accused is my neighbor. The occurrence took place about 1.5 years back. On the date of occurrence at about 8:30 p.m., my wife and I took meal at that time. I heard halla in the house of Pankaj Nath. There was quarrel between Pankaj Nath and his wife. As the house of the accused was just in front of my house, I saw that the wife of the accused was about to leave her matrimonial house, but the accused was objecting to her leaving matrimonial house. My house is in front of the house of the accused, and it was at a distance of about 40 feet from my house. I made statement before police in connection with this case. I stated before police that sometimes the accused and his wife quarreled each other. I stated before police that on the date of occurrence at about 7:30 p.m., Pompi Devi caught fire on the road and she was crying, and I, along with Pankaj Nath and others, pushed to the place of occurrence to put out the fire caused by defense. At a relevant time, there was altercation, quarrel between Pankaj Nath and his wife, deceased Pompi Devi, over the issue of her leaving matrimonial house. Pompi Devi was coming out of her matrimonial house with an oil kerosene lamp in her hand. We saw Pompi Devi caught fire when she came out on the road. I, along with Pankaj Nath and others, doused the fire. On seeing the occurrence, my wife became senseless, and then I took my wife to hospital. So I do not know about the subsequent event.
So from the cross, it looks like he had seen Pompi Devi in fire
Yes.
when she was out on the road.
I would suggest,
Construction of sentences. Yes.
I would suggest the lordship will have to may read the sentence which favors the accused. And secondly, if lordship said Pompi Devi was coming out of a metro with an oil kerosene lamp in her hand,
Hmm.
So if it was the accused who was pouring it the kerosene lamp, how could the victim have the kerosene lamp in her hand?
Hmm.
Secondly, and it is specifically clear in his own statement, what fire on the road. It's not that she was coming her body on fire from inside the house.
Okay.
That's
So you have read up to PW6.
yes,
Let us go to 7 and 8.
yes. 7 is the medical officer who signed the dying declaration along with the IO.
Yes. Let us see what he says.
Yes. From 8 p.m. of 21/10/14 till 8 a.m. of 22/10/14, I was on duty as casualty officer at Tezpur Medical College and Hospital. During that period of my duty, one Pompi Devi had attended the hospital with severe burn injuries, and we immediately made dressing of the injuries and gave adequate treatment to her in the minor OT at emergency ward. After 12 a.m. at night, the police officer of Thelamara PS came and recorded the statement of the said patient in my presence. The victim injured during the said statement has stated that her husband had burned her. I have put my signature in the statement recorded by the police in my presence. Exhibit 2 is the said statement, wherein exhibit is my signature. The said patient was subsequently referred to Guwahati Medical College for better treatment. But he does not make cross. It is not a fact that I was not present along with the patient victim at the time of recording statement. Exhibit 2. The exhibit 2 by police. I put my signature on the statement giving time as 12:30 midnight on 22/10/14. I forgot the name of the police officer who had recorded the statement. It is not a fact that at the time Pompi Devi was not in a position to give any statement. I was not detailed by my superior to be present at the time of recording statement of the victim injured by the police. I have treated Pompey Devi on that day. It is not a fact that I have not treated Pompey Devi. It is not a fact that some other doctor had treated Pompey Devi. I do not remember as to who had referred Pompey Devi for further treatment at Guwahati Medical Guwahati. I could not say the exact time when Pompey Devi was brought to Tezpur Medical College and Hospital. I was on duty at Tezpur Medical College from so and so, and Pompey Devi was brought during the said period. But I could not say the exact time when she was brought and took treatment. I have not recorded the statement under section 161 of the CRPC as because I was not entrusted with the same. It is not a fact that I have not heard the recording of the statement of the patient. It is not a fact that I have simply put my signature on the statement. Pompey Devi was born with more than 80% at the time of giving the statement. It is not a fact that Pompey Devi with more than 80% injury had never given any statement. It is not a fact that I have falsely stated that she gave such statement. It is not a fact that I was busy with other patient at the time of recording the statement. It is not a fact that I do not know about the recording statement by police. It is not a fact that after refreshing my memory, I have falsely deposed before the court today.
So it is also not the case of the appellant that the victim was not in a fit state of mind or not in a position to speak.
Though he does not stay in his deposition, but he clarifies in the cross. That should not have been put to him. He clarifies in his cross.
Mhm.
The statement was not there in the deposition.
So cross-examination, that keeps eluding. There is problem everywhere.
The sketch map doesn't indicate the house of PW.
How long? That's
No, it
what
does,
we
it
were
does.
about. What is the distance between house of PW1
40
and
meters, it does, your lordship. It does. That I have seen. it. No, no, Pankaj.
PW1.
Pankaj Nath is
PW2.
the son of Pranjal Nath. That I have seen, your lordship.
Yes, which page?
Because that is only, I'm relying on only that sketch map is, your lordship will find
Page 56.
56. Ungo is the house. Just opposite across the road.
Here indicates the Jagat Chandra Nath.
Huh.
Jagat Chandra Nath.
He is the father of PW1. Your page 9, your lordship.
Page?
9. Father's name is Jagasindra Nath. He is the only one who can directly witness because others have come after the incident. Page 9, retweet page 56 and 57. Ungo indicates the house of Sri Jagat Chandra Das about 8 meters away to the south of the place of occurrence. So this house is there. He's the only one.
All right, so that is so far the doctor is concerned.
Yes.
And PW8 is the IO. IO's testimony must be pertaining to usual investigation.
Yeah, and I
Anything
would
significant in PW8?
sorry.
Anything significant?
Even
in
nothing significant. I would rather say, your lordship, the grandfather who is a complainant, he has tried to falsely bring out a case of dowry because there's been no mention of dowry in the father's testimony, nor in the dying declaration, nowhere. He is the only one here. So whether he's tried to falsely implicate the accused, one thing. Second, there is contradiction at whether where he met Mr. Dilip Nath, because Dilip Nath, the father, he says he saw his daughter for the first time in the hospital. But whereas in his deposition, he says, I was at the home. And the grandfather says, well, after visiting the hospital first, when he returns to Dilip Nath's house, he met him there. So they are confusion and contradiction, whether they are trying to create, so they are contradiction in the sense now, whether they are material to or not. because-
So what happened really? What actually happened?
Your lordship, one thing is clear, that the death has occurred due to burn injury. And the incident has happened outside the home. Whether now she caught fire inside and came out, or whether she doused herself or lit herself in fire outside her house, that has to be decided. PW1 says it outside. Others are saying, but though they are not direct witness, they are saying on the basis that the victim says so. Now, victim dying declaration, how far it is reliable? Because of the fact the grandfather was present, and the grandfather is the complainant. And she herself says after fire was doused, she ran for 1 kilometer or 1 mile to the other side of the river to her father's or mother's house, which is improbable. In doing so, whether the dying declaration.
What is the explanation of the accused?
313 statement. He says in his statement,
Yes.
page 32.
Mhm.
Page 32, last question of explanation. Do you have to say something? I'm innocent. It is a fact that I came home drunk from market. As soon as I arrived home, my wife hit me with a broom. I slapped her twice. Then she wanted to go to her home by taking a kerosene lamp. The neighbor also know this, but she near a pool near my house poured kerosene on the lamp and set herself on fire. I and my brother ran towards the victim while the fire over her completely set off. She ran towards the house. The house is near to my house. I did not follow her because the uncle and the relatives ineligible for me to kill me. So he was fearing they would do something. So I also received from injury and cure while in jail. My wife do not use again. And interestingly, your lordship, the postmortem report, the doctor has not been examined. The postmortem report, whether that can be now taken into evidence, keeping in mind the doctor has not been examined. So we'll have to rely only on the popular evidence.
Lethargy. Maybe the public prosecutor didn't even know that the postmortem report is required to be proved. Yeah, we have public, most of them are.
And all the family members, whether they're trying to bring out a case, has to be seen from the deposition of PW4, who is the cousin, who says that I saw the victim coming out in burnt condition from a house, but while in cross he admits his house is 2 kilometers away, he met her only in the road. He couldn't see. So this shows there is some falsity in the evidence of the family members. PW4 is page 16, your lordship. He is the cousin.
Yes. Okay, now let us read the findings of the trial court.
Statement start from paragraph 19, page 45.
Paragraph 19, page 45.
Yes, sir. In the present case, it is to be kept in mind that no material offense seized by the investigating officer, because the lamp and nothing was seized, not the clothes, nothing examined. Nothing seized from the place of occurrence, but the fact remains that the victim died due to burn injuries. As per the sketch map of place of occurrence, the incident occurred in the house of the accused. On the bed itself, the victim was set on fire as per the sketch map. The PW1 said that the Pompey caught fire on the road and she was crying, and he with the accused and others rushed to the place of occurrence to put out the fire. Victim came out of a material home with an oil kerosene lamp in her hand. They saw Pompey caught fire when she came out on the road. It cannot be read into the evidence of PW1 that the victim was set off set on fire on the road. Your lordship, I would say that this finding is with great humility incorrect. The PW1 said that he noticed that the victim engulfed in fire when she came out of the house. The defense has not brought out from PW1 that the victim did not receive injury while inside the house. The PW1 has mentioned regarding the presence of the accused at the place and said that they tried to put off the fire. The PW1 stopped midway, but it is proof from the statement of PW1 that just prior to the incident of setting fire on the victim, a commotion took place inside the house of accused. The plea that the PW1 and the accused tried to put out the fire cannot be accepted in view of the fact that the defense failed to bring out from the mouth of the witness remarkable steps taken by the husband to save his wife. In the catena of judgments of the Honorable High Courts, it is specified that evidence of hostile witness can be considered for either side, that is for the prosecution case and the defense case. The defense has not denied that fact of the victim caught fire, ran out of the house. The PW2 said that he saw the victim in a paternal home with burn injury. The father of the victim, PW6, also said that he found his daughter in his house, and from there they brought her to the hospital. From the chronology of events, it can be held without dispute that as soon as the victim was set on fire, they ran out of the house and somehow reached her paternal home. PW6 has not tried to develop the fact regarding finding the victim in his house just after the incident. PW6 has said that the neighbors took the victim to the hospital. The accused, when examined under section 310, mentioned that the victim went to her father's house, which is situated near his house. It can be held without any doubt the victim herself or the neighbors brought the victim to the house of the PW6 and then to the hospital. PW1 said that the victim was crying when she came to the road. As per PW1, the incident occurred at around 8:30. PW6 immediately came to the house and found his daughter with burn injuries. PW6 said that when asked, the victim was told that the accused set her on fire. The PW7 said that at around 12:30 midnight in his presence, police recorded the dying declaration of the victim. Though the IO said that the victim has received 90% burn, it is not brought out from the IO and the doctor by the defense that the victim was not in a condition to talk at the moment. The PW8 exhibited the postmortem examination report of the victim as exhibited 4. As per the postmortem report, the victim died on 27/10/20. The following is mentioned in the postmortem report. May I read or?
So postmortem report was exhibited by whom?
No, by the, your lordship will see the IO has stated, but the doctor has to give his definition.
Our lordship may not be.
But the IO has exhibited.
So then you said postmortem report.
But ultimately, it is postmortem says nothing, nothing much apart from the.
But is there any dispute that she suffered burn injuries?
No, that no one is because defense story is that she succumbed to death by lighting herself. So,
So only question is whether she self-immolated or
right,
it was a case of her husband setting her ablaze.
yes. Now, 304 is not there. No one is able to brought out the case of 304. Secondly, your lordship, he returned at 3:30, intoxicated. But incident happened admittedly after dinner. So, and that time also as per PW1, there was a quarrel. And the father statement cannot be relied because he tried to bring new facts or new incident which he admitted in his cross for the first time. And even if it is relied, it is not practical for a father when he hears the halla near his, he was in Homeshwarnath's house, which is near to the accused house, but he went to the other side. So here's whether there's credibility in his evidence. And also the cousin's evidence and the grandfather's evidence. Because it doesn't, it is not clear as to where they meet Dilipnath as well as the victim for the first time. And how the victim was from the place of occurrence to the mother's house or father's house, Dilipnath's house, how she went there. It is only by her own statement that she ran.
All right, let us read the judgment.
Yes. The following is mentioned in the postmortem report. A female dead body of average build found wrapped in surgical bandages from neck to ankles, eyes, mouth closed. labia, banana, anus burns, clinging of hair present, rigor mortis fully developed, body cold on touch, burn injuries present all over the body except the following part. So answer your lordship. From the evidence of Pidoli 6 and Pidoli 3, it is not reflected that they had met the accused just after the incident, but they had narrated what happened prior to the incident. Pidoli 6 narrated the chronology of events that took place in the house of the accused since the afternoon. Pidoli 6 said that in the afternoon, the accused came home drunk and entered into altercation with the victim, and at night, the incident of setting fire on the victim took place. The chronology of events do tally with the dying declaration given in the victim at night. These are, they have relied on few judgments whether the dying declaration give full confidence and whether the disease was in a state, in a fit state of mind or not. Your lordship, should I read or?
Yes,
In Panivan versus State of Gujarat, 1992 SCC, the Honorable Supreme Court observed as follows. Though a dying declaration is entitled to great weight, it is worthwhile to note that the accused has no power to cross-examine. Such a power is essential for eliciting the truth as an obligation of oath could be. This is the reason the court also insists that the dying declaration should be of such a nature as to inspire full confidence of the court in its correctness. The court has to be further satisfied that the deceased one in a fit state of mind after a clear opportunity to observe and identify the assailant. Once the court is satisfied that the declaration was true and voluntary, undoubtedly it can base its conviction without any further corroboration. It cannot be laid down as an absolute rule of law that dying declaration cannot form the sole basis of conviction unless it is corroborated. The rule requiring corroboration is mainly a rule of prudence. The court has laid down several judgments, the principle governing dying declaration, which could be summed up as under. There is neither rule of law nor prudence that dying declaration cannot be acted upon without corroboration. If the court is satisfied that the dying declaration is true and voluntary, it can base conviction on it without corroboration. The court has to scrutinize the dying declaration carefully and must ensure that the declaration is not the result of tutoring, prompting, or imagination. The deceased had the opportunity to observe and identify the assailant and was in a fit state to make the declaration. Here I rely on tutoring, prompting, or imagination because of the presence of the family members as well as the last statement of the victim. When dying declaration is suspicious, it should not be acted upon without corroborative evidence. When dying declaration was unconscious and could never made any dying declaration, the evidence with regard to it is rejected. And dying declaration which suffers from infirmity cannot form the basis of conviction. Merely because a dying declaration does not contain the detail as to the occurrence, it is not to be rejected. Equally, merely because it is a brief statement, it is not to be discarded. On the contrary, the shortness of the statement itself guarantees truth. Normally, the court, in order to satisfy whether disease was in a fit mental condition to make dying declaration, to look up the medical opinion. But where the eyewitness has said that the disease was in a fit conscious state to make the dying declaration, the medical opinion cannot prevail. When the prosecution version differs from the version as given in the dying declaration, the said declaration cannot be acted upon. It is the prosecution's own witness, only one. And when dying declaration is suspicion, it should not be acted upon without corroborative evidence. These two principles I will rely on. The argument cannot be accepted that the dying declaration is an afterthought and manufactured one, because the contents of the dying declaration differs materially with the contents of the FIR. The accused, when examined under section 313, mentioned that in the afternoon he came to the house drunk and hence his wife hit him with a broom and hence he slapped his wife. Hence, there is no reason to discard the dying declaration so made by the victim. The PW 6 is the father of the victim. His house is situated near the house of the accused. PW 6 has not mentioned that the victim was tortured by the accused after marriage, demanding dowry. It is admitted by the father of the victim that there was a love affair between his daughter and the accused, and the victim eloped and married the accused. The dying declaration does not mention anything about dowry. Hence, the incident cannot be termed as a dowry death. The prosecution has exhibited the extract copy, so and so, made in Halamana section. In the GD entry, it is mentioned that the information received from Bhigauri OP that one daughter-in-law has been set on fire after pouring kerosene. Then one ASI with the staff proceeded to Gaboru, Portugal. The police recorded the dying declaration after 1.5 hours after receiving the information. Thus, the steps taken by the police cannot be termed as lapse. The steps taken by the police in no way affected truthfulness of the prosecution case. In Brazalal Dev versus others was a state of Tripura. The Honorable Guwahati High Court has observed as follows. Insofar as the specific deficiencies pointed out Mr. Kar Homik on the earliest information received by the police, not being the starting point of criminal process or where the point from where the injured witness rushed to the PO, not.
All right. We have seen the judgment. So the trial court holds that the charge under 302 has been proved beyond all reasonable doubt. You address the court. The only material appears to be the dying declaration. Otherwise, there is no clarity on how she caught fire. So, is the dying declaration acceptable? Is it reliable, trustworthy? Or is it to be discarded or not taken into account without corroborating materials, as he is suggesting? And if that be so, can it be said that the prosecution witnesses contradict the story projected in
Paragraph 20, Your Lordship.
paragraph 20?
Yeah. It is also not obligatory that either an executive magistrate or a judicial magistrate should be present for recording a dying declaration. It is enough that there is evidence available to show that the dying declaration is voluntary and truthful. But here there could be occasions when persons from the family of the accused are present. And in such a situation, the victim may be under some pressure while making a dying declaration. In such a case, the court has to carefully weigh the evidences and may need to take into consideration the surrounding facts to arrive at the correct factual position. So in this case, Your Lordship, what I'm submitting is that since the grandfather, who is the complainant, was present, who was deposed in his evidence that he was present while making the declaration. So the court, this honorable court has to look into the other surrounding facts, the evidences of the other witness. PW1 has given direct evidence that he has seen the victim lighting herself up. PW3, the grandfather, he has tried to falsely implicate the case of dowry.
Who has said he has seen the victim lighting herself up?
In PW1,
PW1 said so.
caught fire on the road.
Oh, that is another thing. You can't use that to say that he saw the victim lighting herself.
I'll then rephrase myself also.
Hmm.
One is he saw the victim coming from the house in a burnt condition. He saw the victim in a burnt condition in the road. And he saw her coming from the home with a kerosene lamp.
So, Mr. Sharma, what we are asking is, does the testimony of PW1 negate this theory that victim had caught fire and then she came to the road?
Yes,
In what manner?
because in the cross-examination, because he says Pompey David caught fire on the road. And second, he saw the victim coming out of a matrimonial house with an oil kerosene lamp. The whole theory is that the husband put the kerosene from the kerosene lamp inside the house. If that be the so, it is highly improbable that the victim would carry that lamp in a burnt condition and come out. Rather, a victim in such condition to stay away from inflammatory things. So that is my humble submission. Second is that PW4, the cousin, he has contradicted. He is trying to falsely bring out the case, being an interested witness. Because he says he saw the victim coming out of her house in burnt condition, whereas in his cross, in page 16, Your Lordship, in his cross, he says that his house is at a 2 kilometer and he met the deceased on the road at a distance of 1 furlong. So he met her on the road. He didn't see the victim coming out from the house in burnt condition.
But he also brings in an oral dying declaration.
Your Lordship.
He also brings in an oral dying declaration.
Right.
He says the victim told him
Yes.
that her husband has set her ablaze. Was this statement challenged in the cross? On being asked as to how she caught fire, she told me that her husband poured kerosene on her body and set her on fire.
My humble submission would be, Your Lordship, when the evidence has to be there in entirety, because when he has falsely deposed in one condition,
Hmm.
whether his evidence should be reliable and would be the basis. for that.
Falsely deposed on what point?
On your lordship, he says, on oath, on the relevant day,
Hmm,
at about 7 p.m.,
hmm.
I saw disease Pompidevi was burning and came running from the house of the accused. So he says he saw the victim coming from the house, but he stays around 2 kilometers in his cross at bottom. My house is at a distance of 2 kilometers. On the same page, your lordship, my house is at bottom. My house is at a distance of about 2 kilometers from the house of the accused.
Hmm.
I met the disease on the road. So he doesn't say he saw the disease.
So, Mr. X stays in Beltala. His house is in Beltala. He saw a stabbing incident near the High Court. Therefore, he could not have seen it. Is that what you're saying?
No, what I'm saying is.
Did he say that after hearing the commotion, I was at home, I started from my home, on my way to the house of the victim. There I met her and I saw these questions, these statements are not there.
Yes, no, what I'm trying
And
to.
there is also nothing to suggest in the cross that this is a false statement made by him.
No, what he says is that he saw the victim coming from inside the house. So
Yes,
this
his
is a-
house could be 2 kilometers, but he might have been there at that place. That question was not posed to him. He was not challenged.
My house is at a, your lordship,
Yes. No, first of all, have you understood what we
I-
are asking you?
yes. he
His
be
house may
challenged.
be 2
Yes.
kilometers away,
Yes,
but he might still see the victim.
right,
He might not have been in his house.
yes.
But that argument can you make unless that is put to the accused in the cross? You never asked any question. You means, obviously we are referring
Yeah,
to.
yes, I understand.
Hmm. On being, it says, I saw the burning and came running from the house of the accused. Come running. The occurrence took place so and so. So he says he saw the victim. She was running away from the house of the accused in a burned condition. On being asked, she said that her husband had put her on fire.
Right,
Then in the cross, a question was asked, where is her house? He says 2 kilometers away. Then the next question should have been, and ought to have been,
whether he
that
was-
you could not have seen it.
Yeah.
Then we don't know, he might have given an explanation. Cross, the witness is permitted to give an explanation. You did not ask him. So now how can you say that at that time he was in his house and he could not have seen? These arguments you can't make. What is the basis of this argument? If you would have asked him that when the incident occurred, were you at your home? If you would have said yes, oh yes, then legitimately. Or if there is any other evidence which says that he was at his home, then this 2 plus 2, you can make it that if he was in his home, it was 2 kilometers away. How could he have seen this? Then there is obviously there is a break in the chain. But from this testimony, how can you say that? These are 2, 3 disjunctive facts. Where is her house? 2 kilometers away. Did you see her? Yes, I saw. What did you see? This. He was not in his house. He was walking somewhere near the house of the possible, is it not? So can you argue that unless the witness was crossed on that particular point, or there is some material to show that he has contradicted himself? Where is the contradiction? You have to show us the contradiction. Where is the contradiction? This is an imaginary contradiction. You are imagining that if this has happened, then he must have been at home. And if he was at home, then how can he see? But these are all figments of imagination.
Yeah, I know what is falling for your lordship. Then I'll just rely on the last sentence of the.
Please don't hesitate in arguing.
Right.
We are putting these questions because we want to know from you.
No,
Feel
from
free to
evidence
argue
itself.
your points. We'll hear you. Whatever point you want to argue, you argue. With conviction, you argue, there is no difficulty.
Right.
We will consider, appreciate, and then see what happens.
Yes, as I was saying, then your lordship, what is falling
Don't,
short?
don't concede to something coming from the court. If you are not convinced, if you are convinced, then you concede. Otherwise, you are entitled to give a response.
Only thing, the last statement of the cross, I met the disease on the road at a distance. But as your lordship says, I met the disease and reading came running out of the house.
There is a link which is missing here.
Yes, sir.
Without that link, you can't say that he could not have seen the accused. I mean, the victim. You can't say that. Because these are two disjunctive, you see, independent facts, which if stitched together with some conjunctive material, then it would probably possible. If you would have said at that time he was at his house, oh, then it will make a, then it will contradict him. But that question was not put.
Then only answer to this, your lordship, is that he is the cousin of a victim and the PW1 is the independent witness.
Hmm.
That is the only, when PW1 witness is totally different from what PW4 is saying.
That you have said, you have noted it.
So, yes, and secondly, as since the family member was present and the supporting evidence, other evidences, so I humbly
There is no
submit-
doubt PW1's testimony is damaging for the prosecution.
Yes.
We'll see how she.
No, that is my only case, because the dying declarations, in this case, because of the presence of the family member, the dying declaration cannot be the sole basis for conviction of the accused. The surrounding evidence, other evidences and effects has to be considered, and keeping in mind the evidence of PW1. So he ought to be recharged. And your lordship, PW3 is also the informant that has to be kept in mind. And there is the father of the victim. His evidence is also not reliable because he has contradicted himself. Though those contradiction does not go to root of it, it shows that they are trying to project a case of the victim, of the accused burning the victim, whereas it might be for some other reason. We don't know whether she lit herself or by what accidentally, we don't know.
So we'll see what these witnesses have told the police. What did the PW1 tell the police? What did the PW4 tell the police? We'll start with that first.
If need be, then I will give a reminder.
All right.
Obliged.
Ms. Bhuya, can we start with their 161
Yes.
statement?
PW1 মানে প্রাঞ্জল
Yes.
তেওঁ সোধপোছ কৰাত তেওঁৰ বয়স 25 বছৰ। তেওঁ এজন কৃষক বুলি কয়। পংকজ নাথে পম্পী দেৱীক পলুৱাই অনাৰ পিছত বাপেকে তেওঁলোকৰ ঘৰৰ সন্মুখত থকা মাটিত ঘৰ সাজি পংকজ নাথ ও পম্পী দেৱীক সংসাৰ কৰি আছিল। তেওঁলোকৰ মাজত মাজে মাজে হাই কাজিয়া হৈছিল। যোৱা সন্ধ্যা 7:37 মান বজাত আমাৰ ঘৰৰ পূবত থকা গাঁৱলীয়া ৰাস্তাৰ ওপৰত পম্পী দেৱীৰ শৰীৰত জুই লাগি চিঞৰ বাখৰ কৰা শুনি, লৰ্ডশ্বিপ উইল কাইণ্ডলি নোট দ্যাট পাৰ্ট, আগুৱাই গৈ জুই নুমুৱাৰ চেষ্টা কৰো। So she was already on fire. মোৰ লগত পংকজ নাথ আৰু ওচৰৰ কেইবাজনো লোক আছিল। জুই ক'ত লাগিছে দেখা নাই আৰু কেনেকৈ লাগিছে নেজানে বুলি কয়। আৰু জুই নুমুৱাৰ পিছত তেওঁক বালিগাঁৱৰ পৰা পম্পীৰ মাক দেউতাকো কিছুমান মানুহ আহি টেম্পু গাড়ী এখনত উঠাই পম্পীক চিকিৎসাৰ বাবে লৈ যায় বুলি তেওঁ কয়। Is the statement of PW1.
And no mention of any kerosene lamp in her hand, etc.
No, nothing.
Yes. And what is the statement of PW4?
Oh, Babu. যোৱাকালি ইংৰাজী 21/14 তাৰিখে সন্ধ্যা 7:30 বজাত ভনী দেৱীৰ গাত জুই লগা খবৰ পাই দৌৰি সিহঁতৰ ঘৰৰ ফালে যাওঁ আৰু তাইৰ খুৰত জুই জ্বলি থকা দেখা পাওঁ। মই গৈ পোৱালৈ জুই নুমাই মই ভনীক সোধাত তাইক তাইৰ স্বামী পংকজনাথে তাইক অত্যাচাৰ কৰি কেৰাচিন তেল গাত ঢালি জ্বলাই দিয়ে বুলি কয়। পিছত মই লগে লগে তাইক গোট খোৱা মানুহৰ সহযোগত টেম্পু গাড়ী এখন পাই চিকিৎসাৰ বাবে TMCH লৈ ভৰ্তি কৰাই চিকিৎসা কৰাও বুলি তেওঁ কয়।
Now, this statement of this witness was recorded the next day. That is
PW?
22nd. PW4
Statement it
was
was
recorded on
recorded on
22nd.
22nd.
22nd, right?
Yes, yes.
And when was the dying declaration of the victim recorded? Is there any mention of date and time?
Yes. Page 54, your lordship. 50,
Page 55.
page 54, yes. It's on 22/10/2014, 12:30 midnight.
So definitely before her statement was recorded, the statement of PW4 was recorded.
Lordship, may I see the timing?
Just
Yes.
check once.
Mhm. পুৱা 10:15 বজা lordship, it's it's on 21:10. This,
Which is on 2110?
lordship, this first GD entry was there.
Hmm.
It's on 21:10, then continuation 11 boja, then so and so rati 11:30 boja, rati 11:50, 12 boja, then lordship 21:10, 22:10, 12:05 boja, 12:15, lordship, just a minute. It would be on the next date, your lordship.
No, what we want to find out is that was the statement of PW4 recorded by the IO before the dying declaration or after the dying declaration?
I think after the dying declaration. Because dying declaration was recorded as per in page 55, 12:30 midnight, 22:10 likha ase. 22:10 who goes about the time. Occurrence of 21:10, my lord, at the 7:30. Then dying declaration 12:30 midnight means then midnight, then it would be next day, your lord, 22:10. This sort of one.
22:10 likha ase.
Yes.
Because he is in his IO.
No, I see any note of the iOS thing. There's a note of the IO, my lord. এই ঘটনাৰ বিষয়ে স্থানীয়ভাৱে তদন্ত কৰি সাক্ষীবাদী সোধপোছ কৰি পম্পী দেৱীক তেওঁৰ স্বামী প্ৰাঞ্জল নাথে গাত কেৰাচিন ঢালি জ্বলাই দিয়া বুলি জানিব পৰা হয়। এই দুৰ্ঘটনাৰ সংক্ৰান্তে জখমী পম্পী দেৱীক ওৰফে সৈনিক চিকিৎসালয়ত চিকিৎসাধীন অৱস্থাত সোধপোছ কৰো আৰু তেওঁৰ স্বামী পংকজ নাথে তেওঁৰ শৰীৰৰ শুই থকা অৱস্থাত কেৰাচিন ঢালি জ্বলাই দিয়া বুলি চিকিৎসকৰ সন্মুখত স্বীকাৰ কৰিছে। So notice prior to after the recording of this one Babul Nath's statement, Your Lordship.
Babulnath was recorded earlier.
Yes.
All right.
Lordship, as far the whatever my learned friend has made the argument, Your Lordship, the victim was carrying the lantern, Your Lordship. Even in 313 also the accused person says she was carrying the lantern in order to, because they had some altercation, she wanted to go to her home. And my contention is that since it was night, Your Lordship, it was a village. As a result of it, she was carrying the lantern. And lantern, Your Lordship, is aware that kerosene lantern doesn't carry so much of oil. So as to, Lordship, she got 90% burn. It's not possible. And she got injury on her back also, my lord.
But are you saying after a person is set ablaze, she will go to the road carrying a lantern in her hand?
It's not possible. That story is, Lordship, cannot be believable.
Then that's the prosecution story.
But Your Lordship, if Your Lordship sees the PW1 only, because to the other witnesses she has deposed, oral dying declaration part is there. And Your Lordship, in 313 also, this accused person says the presence of PW4, brother is there. He says brother is PW4, my lord. Happens to be the cousin of the
Where is it?
victim.
Let us see.
313. Yes. Lordship, page 32, last question. I am innocent. It is the fact that I came home drunk from market. As soon as I arrived home, my wife hit me with a broom. I slapped her twice. And then she wanted to go to her home by taking a kerosene lamp. The neighbor also know this, but she near a pool near my house poured the kerosene of the lamp and set herself on fire. I, Pranjal, and my brother ran towards the victim. And see the conduct of the accused person, Your Lordship, she didn't try to take her to the hospital. He fled away from the scene, my lord. And Your Lordship, the dying declaration part is consistent, Your Lordship. It's devoid of any infirmity. So, Lordship, rightly the learned trial court, basing on Lordship, the conviction is given on the basis of the dying declaration. His Lordship, it's before she gave oral dying declaration, Lordship, before PW4, before her grandfather, PW3, as well as for PW6, my lord. And Your Lordship, dying declaration doesn't suffer from any infirmities, Your Lordship. Doctor has given her his signature. She was in a fit state of mind because in her statement she also given her nickname also she has uttered, Your Lordship. So Your Lordship, conviction is rightly given. My respect to submission is that.
All right.
Lordship, the PW4, if evidence is, the statement is taken prior to it, then it creates more that suggestion of being tutored. Because PW4 is the cousin of the victim. It looks more tutored because another family member was present, the grandfather. And he is the cousin. His statement was taken prior to the dying declaration. So it creates more doubt of being tutored. And also the surrounding circumstances of purely one.
So according to her dying declaration, when she was in the bed, the husband had poured kerosene and lit a matchstick. Correct. And according to the accused, up to slapping part is common story, both
Yes.
both persons. So before that, what happened is there is no doubt about it.
Yes.
The variance is only to this extent that according to the victim, when they went to bed, then he did this in the bed, on the bed. Little difficult.
And also after
Why
that-
would someone be set on fire on the bed?
No, she was about to sleep.
No, you
About
look
to
at,
sleep, your lordship, can you see? Page
I had
54.
gone to bed. I had gone.
So there was no quarrel then. Sorry.
After I had gone to bed. After I had gone to bed. Is it not?
Yes.
So if this version is to be believed, the victim was set on fire by pouring kerosene when she was on the bed.
Yes.
Is there anything on record which no scissor, nothing that
No,
if
nothing.
this,
Nothing, my lord.
if a person is set on fire on the bed, will there be nothing available?
No scissor list, nothing is there. May I see any vernacular? I don't know, it's translated or something.
Yeah,
Exhibit 2.
have a look, have a look.
Yes.
What is the vernacular? Can you please flag mark it also?
Yes, your lordship. It's in vernacular, no? Mary. মোৰ নাম পম্পী দেৱী ঘৰত ভনী নামেৰে মাতে মোৰ বয়স 15 বছৰ যোৱা জেঠ মাহত গাভৰু কোচগাঁৱৰ শ্ৰী পংকজ নাম পিতা মহেন্দ্ৰ নাথৰ লগত ভালপোৱা সূত্ৰে পলাই আহি সংসাৰ কৰো মোৰ মা দেউতাৰ ঘৰ নতুন বালিগাঁৱত মোৰ মা দেউতাৰ দাদা আছে আজি ইংৰাজী 21/14 তাৰিখে মোৰ স্বামী পংকজ নাথে খেলমাটি বজাৰত গৈছিল আবেলি 3:30 মান বজাত তেওঁ মদ পান কৰি মাতাল হৈ ঘৰলৈ আহে মই মদ পান কৰি অহা কাৰ্যত প্ৰতিবাদ কৰাত মোক চৰ মাৰে সন্ধ্যা 7টামান বজাত ভাত পানী খাই স্বামী আৰু মই দুই একেখন বিচনাতে শুই পৰো। মই খোৱাৰ পিছতে স্বামীয়ে মোৰ শৰীৰত কেৰাচিন তেল ঢালি মেছৰ কাঠি মাৰি গাৰ কাপোৰত জুই জ্বলাই দিয়ে। মোৰ গাত জুই লগাত স্বামী পলাই যায়, তেতিয়া গাঁৱৰ মুখীয়া লোক আহি জুই নুমাই দিয়াত ময়ো দৌৰি পিতৃৰ গৃহত আহো। মোৰ ক'বলগীয়া ইমানেই।
See, there are two things here.
Yes.
First of all, according to the dying declaration, she was set ablaze by pouring kerosene after she went to bed.
Yes.
This is number one.
Yes.
And number two, the husband ran away, fled the scene after that. So first part is pouring kerosene and setting someone ablaze when the person is on the bed. Unusual, but then there is nothing to indicate that something of that sort happened. Second, the witnesses have found the accused at home. When they
Yes.
went and saw the victim was on fire, they found the accused at home. So these two things don't tally, at least this much does not tally with the,
No, Lordship, but accused insists he was not there. He fled away.
where does it
In
say?
313, my lord.
He fled away later after the relatives started coming.
I did not follow her because the uncle and relatives told me to, no, the house is near to my so-and-so, or Lordship, prior to that. I, Pranjal, and my brother ran towards the victim while the fire over completely set off. She ran towards her house. The house is near to my, I did not follow her because the uncle so-and-so killed me from injury, so-and-so.
So he ran towards a victim. But
Hmm. Yes.
The evidence of PW1 is creating trouble to your Lordship's mind. But going to 161 statement, he Lordship visited subsequently, my lord.
His evidence seems to fit into the explanation of the accused. That's the trouble. Yes. That is the biggest trouble. Have you followed what we are saying?
Lordship.
That part of the evidence of the PW1, who is a natural witness, being the immediate neighbor opposite the house of the accused, he evidently rushed to the place and was one of the first to arrive there, probably the first. He says something which fits into the explanation given by the accused, that she was carrying a kerosene lamp in her hand. Now the question is, victim went to bed, accused poured kerosene oil on her, she was on fire, she came out on the road and she was carrying a lamp. Somebody who is on fire,
Yes.
can that person come out on the road with a lamp to see what is there in the, oh, that is a
Unbelievable.
unbelievable situation. And
But the Lordship will take into account entire evidence on record, not only the evidence of PW1, my lord.
what else is there in this case? What else?
Then the oral
There
dying
was a point
declaration
given
part,
there.
my lord, oral dying declaration part, your Lordship, to the other PWs.
That's what we are asking you.
Yes.
If the testimony of PW1 seen in the light of the explanation of the accused is seen, then the oral declaration, dying declaration cannot be held to be trustworthy. There is contradiction. That's what is case. There is material contradiction on that. these two things project different versions. The oral dying declaration and what the PW1 is saying projects completely different version. And if you try to reconcile, then it gives you a completely improbable situation where the victim was on fire and she wanted to go to her parents' home while she was burning. So she took a lamp in her hand to see what is there in the load. A little difficult to accept. If somebody sets one person on fire, the victim will run for whatever he or she gets to save herself.
Yes.
Getting a lamp means to protect herself from falling down or. Oh, can you imagine someone
Yes,
who is
my
in
lord.
fire and get me a lamp so
So
that
it's improbable,
I don't fall and
lordship.
break my bones or
My
something like
lord.
that. Why do you need a lamp to walk out in the road?
Yes, but the amount of oil that lamp it can be put in a lamp, your lordship, it's not enough to burn a person with 90% burn injury.
No, that's not the point. Point is, what is there on record? What is the prosecution's case? And what materials are there in support of that? So viewed from that perspective, one is, of course, there is a dying declaration. The dying declaration projects a story which does not fit into the other prosecution witnesses, and more particularly PW1. The worrying part is that the PW1's version fits into the explanation of the
Given by the so. Lordship, but when dying declaration inspires the confidence of this honorable court, then your lordship,
When it
because the
doesn't-
person dying will not lie, your lordship.
When it doesn't, then what happens? Who is telling the lie?
Lordship, then your lordship will go through the other corroborative evidences. But here it inspires the lordship, I think, the confidence of this honorable court. So that factor your lordship may take into account.
Is there anything you want to say, Mr. Sharma?
No.
We have not yet decided. The case can go this way or that way. We'll again go through the record very minutely.
Only thing, other witnesses also regarding PW6, the father.
Hmm.
He deposed the oral that the victim had told him about the incident. The thing is that he himself is not clear in his deposition where he met the victim, in his house or in the hospital.
In the
So he's-
hospital, his
no, no.
statement.
So he stays in his
Just ever so-
deposition, he stays in his deposition, he met in the house. So his evidence cannot be taken into account. So he also goes, he will do 4 goes. Your lordship, may I read page 20? Immediately we came to a house and found my daughter in burned condition, and the neighbors took my daughter to Tezpur Medical College. That is his deposition also. So he met the victim in his house. Your lordship, in his cross, next page. Somewhere in the middle. May I read? I have stated before police. Lordship got it?
Which page?
Page 21.
Yes,
I have stated before police
yes.
that I have seen my daughter in burned condition at Tezpur Medical College. It is fact that I have seen my daughter in burned condition at Tezpur Medical College for the first time. So one
No,
here,
at home he didn't meet. Your lordship, page 13. On getting information about the incident, rushed to Tezpur Medical Hospital and she was admitted therein.
and
So
his
in the
deposition-
Tezpur Medical, there are 2 parts, your lordship, my learned friends mixing him up. Lordship, there's oral dying declaration given to PW3 as well as the other PWs, my lord.
PW4, right?
Yes,
Mm.
and your lordship, the other one, your lordship, was recorded by doctor subsequently, the 2 parts.
No, here I am trying to say, your lordship. He says in his deposition that he met his daughter in his house, and the doctor then told him about the incident. But whereas in his cross, he says he's met his daughter for the first time in the hospital. So that oral deposition by the daughter to him has to be disregarded. Because the place of meeting his daughter itself is not clear. It creates a doubt, it's not reliable. Immediately we came to a house.
Yes, he does say that He immediately came.
PW3 is the grandfather.
No,
PW
six,
six,
Oh, six,
PW
oh, কথা কৈছে।
There is some contradiction here.
Immediately we came to a house and found my daughter in burnt condition. Are you inquired? I have stated before police came. I have seen her.
Lordship, because at the first instance, the victim went to her residence, my lord.
No, that's
Then,
correct.
thereafter
What
she
he
was-
is saying
yes.
is that PW6 is the father.
Yes,
There are three circumstances which he is pointing it out. You give your response to it. First, he said that the house of the accused was very close to house of this person, Homeshwar Nath. Correct.
Yes,
In whose place the PW6 was present at that time. So on hearing the halla, PW6, instead of going to the house of the accused, went to his house. That can be understood for whatever reason. But he says on reaching his house, he found his daughter in a burned condition in the house. Then people took her to the hospital. So the victim ran to the house of PW6, her
father.
paternal house. What is the distance between the two houses?
so 1 mile,
1 mile.
yes. And it's across the river. One side is eastern part, western.
There is a bridge.
Bridge has not come out, but there is a river, so obviously there has to be a bridge.
All rivers don't have bridge. You want to see a river without a bridge where people come and go? Plenty in Assam.
yes, it's shown the
By boat
pity.
and.
Broken
But that
bridges.
would that would take more time, that will go again.
Ms. Bhuya, something needs deeper look.
And at the
We'll see.
same time, your lordship, the person before the death, lordship, how the body is burning, she was helpless. She can, lordship, my learned friend has said, she cannot run in so much of speed at 1 kilometer distance. It might be, my lord. Person before there's so much of strength, it comes sometimes, my lord.
No, those things are not. See, this declaration, we don't know. This is what IO says. IO says she has said it. Doctor, it was
Doctor
recorded in
endorsed
presence
it.
of the doctor, but doctor in his deposition has not vouched for the correctness of the.
Yes,
That
but
he
he
has
said
not.
he was also not there.
He was also not.
Later on, he has given an
So
endorsement.
IO has written this.
Yes.
Correct.
So your lordship will examine the correctness of the time declaration.
It don't hurt Mr. R. Sharma, learned amicus curiae appearing for the appellate. We have also heard Ms. B. Bhuya, learned APP Assam, learned senior counsel, bracket APP Assam, bracket close assisted by Mr. J. Das, appearing for the state. None has appeared.
Is
for
there,
the
lordship?
Acha, you were there? You want to say something? What is your name? S?
Burman.
S. Burman. Mr. S. Burman is present on behalf of the informant for respond number 2. Arguments concluded,
You
judgment.
wanted to say something?
Yes, we'll hear him.
Lordship, dying declaration has given before 6 witnesses. PW4, the victim had given dying declaration before the PW4 at the time of incident. And others are before medical. And accordingly, all PWs had given evidence. Therefore, there is nothing, any contradiction regarding dying declaration.
Anything else?
No, Lordship.
Sure. Think about it if you want to argue anything else.
So far, PW one stated that on the hand of the victim, there was a lamp. But nobody stated the lamp on which condition at the time of incident. The lamp in the existing of fire or kerosene condition or not.
You mean to say there is no evidence to show whether it was a burning lamp or a,
Maybe on the hand of the victim lamp. But she had given a declaration, dying declaration before 6 witnesses.
Hmm,
The PW1,
which are the 6 witnesses, PWs?
PW4, PW7, PW8, PW6, and PW3. No, whatever, sorry, 5 witnesses. 5 witnesses.
PW 4, 6, 7, 8, and
8, 6, and 3. PW8, who had recorded dying declaration. PW7 is a doctor before him, dying declaration recorded by police. PW4 is the eyewitness of incident. And 6 is the father of the victim. In presence of PW6, victim had given dying declaration.
yes. So what is your submission then ultimately? What is your submission?
Lordship, dying declaration, all witnesses has given dying deposed about the dying declaration. On the basis of dying declaration, the land court below basically convicted the accused person. Rightly passed the judgment.
All right.
There is no contradiction regarding dying declaration.
Okay.
Obliged.
Before that, the previous matter, which is item number, item 7, you write, heard Mr. A. Ahmed, learned counsel appearing for the appellant, also heard a same, B. has also arguments concluded, judgment without.
4 and 5 may be taken together, man. From one judgment order has been passed. From one judgment, man. The person has been convicted.
Yes.
May I please go? I'm referring item number 4.
What?
Item number 4. The appellants have been convicted for offense punishable under section 120B, G26A, read with 34 of IPC. T20 is a case of acid attack. And they've been convicted for 14 years and compensation of rupees 12 lakh has been. Although it was acid attack, but the substance of acid has not been proved by the prosecution. Allegation charges for acid attack. It was the acid, it has not been proved. Doctor says that such injury, burn injury can be caused by falling boiling water also. And the seized articles were sent to forensic. It was never came back. It was not good. Apart from that, Planet Trial Court, basing on retracted confession of his appellant of item number 4, taking corroboration of 164 statements, which was never proved to PW6, conviction has been given. FIR is lordship. May I please take the FIR first? FIR is at page 4.
How much time will be required? In this
And
matter? Availability of this bench next week onwards, we can't say. So will you be able to conclude it? Today there is another bench at 3 p.m. Huh?
It will take time.
It will take time. Then what will happen is you have barely about an hour today. Then if this remains parted before the bench, I don't know what will be the position. Then we have it on Tuesday, then the same bench is there, we'll hear it. Mr. Chaudhary, if you want to argue, we have no problem, but only thing is.
Bench may not be there. This bench may not be there.
Yes, because I was sitting in another DB with Justice Thakuria. So I don't know whether this bench will continue next week. You want to take a chance, you can take a chance. But if it becomes parted, it will get stuck up till the same bench comes.
The next
Tuesday.
next Tuesday, lordship, is the
The prayer of learned counsel for both the parties. These appeals for hearing again on Tuesday next, that is. So, any other matter, hearing part 2?
Four and five are there. Only on love scene theory. Not much materials apart from that. But then 4 and 5 will take some time. Evidence is little long. But otherwise only last scene. The boy was taken from the house, part 2, 4 and 5. Boy was taken from the house. That's all.
You take a decision. We have no difficulty. Maybe I'll find out whether the bench changes or not.
Tomorrow the bench is there, lordship. We can continue tomorrow also.
Yeah, but tomorrow there is another parted matter fixed. First, we'll go through that.
Next week, lordship. Let us do it.
It will be there in the list.
Yes, it will remain, lordship.
We'll take it up on Monday because then we are in December. So after that,
Yes.
January things will change. That's the reason we are pointing out that your matters may get stuck. Yes, please.
Well, this is a review application.
Hmm.
The basic case before your lordship is it relates to a house rent allowance.
Hmm.
Petitioner was a railway employee, and railway employees are entitled to have quarter.
Hmm.
And if the quarter could not be provided, they are entitled to have house rent allowance. Here in this case, so far the respondent is concerned, he was an officer of railway serving in the central vigilance cell. He was allotted with a quarter that was allotted on 10/5/1994. And there, though he was entitled to type 4 quarter, but he availed type 2 quarter. Thereafter, he constructed his house And after constructing his house below, he went to his house and the quarter was vacated. And this quarter was allotted by somebody else. His name is Abdul Nasar. Now, my lord, the quarter which was vacated, that was occupied by Abdul Nasser, and then he raised a claim that I am entitled to have house rent allowance because of the fact that there is no such quarter which could be allotted to me. That is the precise case before your lordship. And our case is that no, there are grade 4, type 4 quarter, but you have not availed it. Now, my lord,
Who is appearing for the other side?
You can, I will appearing for the private respondent, your lordship.
You are appearing for private respondent.
Lordship, you can, I will be appearing. Your lordship.
We'll take up the matter, we'll dispose it of today.
Lordship, the petitioner, the appearance will start, your lordship, and then he's on his legs, he'll join us.
no, at that point, when this matter was admitted, your lordship passed an order to the effect directing the railway authority to pay the allowances, which is payable to the private responses in terms of the judgment passed by this honorable court. We have paid that amount.
You have already paid the.
Yes, we have already paid that amount. So there is, so far the payment is concerned, there is no such dispute. Our only anxiety is before your lordship that your lordship relied upon a circular. That circular was issued by the general manager construction department. And based on that circular, your lordship has passed this judgment. But at the when this judgment, when this matter was called upon for hearing, that we could not clarify that circular. And subsequently, it appears that that circular is not applicable so far the appellant is concerned.
Achha, which is the circular? Let us see.
Circular is.
It is not circular. Page. Judgment.
That is page 21. On repetition the barcode.
Page 21.
Yes, page 21, paragraph 15. Anyway, not wrong. So may I read this?
Yes, please.
We have gone through the record produced by Dr. Gogoi and we find that the concerned authority of NF Railway certified on 37/2009 that the petitioner would be entitled to draw house rent allowance with effect from 14/7/2009. There is, however, nothing on the record to indicate as to the basis on which the decision to pay house rent allowance to the petitioner from 14/7/2009 was taken by the authorities. 14/7/2009, on 14/7/2009, there was no quarter available to allow. From that date, we paid house rent allowance. His contention is that no, before 14/7/2009, there was no quarter to allot him, and accordingly he is entitled. That is the precise point before your lordship. Whether there was a quarter available for his allotment. And our case is that yes, till 14/7/2009, there was a quarter which could have been allotted to the petitioner, but as he has not availed, we had not paid this. And from 14/7/2009, there was no quarter available for his allotment, and that is why we paid 14/7/2009. And he raised a claim that no, he is entitled to house rent allowance from 15/9/2007 to 12/7/2009. That is, there is, however, nothing on the record to indicate to the basis on which the decision to pay house rent allowance to the petitioner from 14/7/2009 was taken by the authority. The Landlord Standing Council for NF Railway has not been able, that is the problem, has not been able to draw the attention of this court to any material which throws light on the actual vacancy position of the type 4 quarter during the relevant period of time. Not only that, Dr. Gogoi has failed to give any convincing answer to our query as to why those 15 officers, that is with regard to that circular, 15 officers referred to in the departmental communication dated 23/3/2011, enjoying identical pay scale as to the petitioners, were permitted to draw HRA during 25/9/2007 to 14/7/2009. Type 4 quarters. Huh? If type 4 quarters were in fact lying vacant during that period. That was below these
communication.
your lordship will find in the read petition, page 44.
Page 44 of the review petition.
No, read petition.
Where is the read petition?
It is there along with the.
44, sure. আমার কাছে নাই কিন্তু। তারপর আমরা এই নোটটা প্রিপেয়ার করেছিলাম।
Yes.
এটা তো sorry. Lord, this circular, this communication was made Deputy Construction Engineer, Deputy Chief Engineer Construction, DM Guwahati. But that is in the NFL there are two wings. One is the construction wing and one is the general open line. And in fact, below this general manager of this construction was not a part. So at that point of time, this could not be clarified. Only after the delivery of judgment, when this matter was incurred upon, my lord, that has been, it was detected. Now, here, all these persons are drawing same scale of pay as paid to the petition. And they were allotted to, they were allotted house rent allowances. So petitioner urged his claim that as these people were allotted the house rent, why I should be deprived of. And your lordship was influenced by that contention, and as a result, my lord, we could not point out these things.
But what is the answer to this?
My lord,
Page paragraph 6 of our review petition.
The review petitioner states that the respondent read petitioner in support his claim for HRA, with effect from 25/9/2007, relied on a communication dated 23/3/2011, reflecting the payment of HRA to 15% during the period 25/9/2007 to 14/7/2009. The respondent read petitioner contended that if those 15% enjoying identical pay scale were permitted to draw house rent allowance, then denying him for the period amounted to discrimination in contrary to the vacancy position of type 4 quarter as projected by railway authorities. This honorable court accepted such contention and recorded in the judgment dated 25/5/2018 the following observation. Not only that, Dr. Gogoi has also failed to give any convincing answer to our query as to how these 15 officers referred to in the departmental communication dated 23/3/2011, enjoying the identical pay scales, were permitted to draw house rent allowance during 15/9/2007 to 14/9/2009, if type 4 quarter were in fact lying vacant during that period. In this regard, the review petitioner states that the communication dated 23/3/2011 would make it clear that the person concerned were all from the construction line of railway, and the detailed particulars of those persons were not available during the hearing of the case. In response to a letter dated 6/7/2018, bearing number such and such, Deputy CPO Constitution such and such provided a verification report regarding the payment of HRA to those 15 persons, while his letter dated 3/8/2018. Now we have annexed that letter. From the said letter, it transpired that the placed in serial number 2, 3, 5, 6, 11, 12, and 14 of the communication dated 23/3/2011 were placed the higher scale than that of the respondent. The read petitioner
Responded and were entitled to type 5 quarter.
higher respondent
And
and the read and were entitled, yes, the read petitioner was touching, read petitioner and were entitled to type 5 quarter. The person in at serial number 2, 3, 5, 6 were drawing HRA from a period prior to 2007. Prior to 2007, okay. And his claim is from 25/9/2007 to 12/7/2009.
in respect of type 5 quarters.
Yes, and actually, where entitled the person person she were drawing a prior to 2007, and the person at serial number 11, 12, and 14 were getting house rent from December 2008 to June 2009, 2009 respectively. Hence, the grant of HRA to those persons having different entitlement of quarters and the different periods have no bearing with the case of the respondent read petitioner. Such payments do not reflect non-availability of type 4 quarter in Maligang area. The letter further provided that yes, one person was paid. The letter further provided that the person placed at serial number 9, PK Deka, was posted Silchar Deputy CST at the relevant point of time and drawing HRA with effect from 16/6/2019. Hence, 2009. Hence, grant of HRA to him is different from that of respondent read petitioner and has no bearing with the vacancy of type 4 quarter at Maligang. Okay. Similarly, here is also observed. Similarly, the person placed at serial number 13 was posted as officer on special duty in Kolkata under Eastern Railway and was drawing HRA from 2/3/2019. Hence, the grant of HRA to him has no relevance with the vacancy position of type 4 quarter in Maligang area. Who for the other person placed in 1, 4, 7, 8, 9, and 10, so they were receiving HRA prior to 2007. Hence,
January 2000.
prior to January 2007. Hence, grant of HRA to them have no bearing on the vacancy position of type 4 quarters in Maligaon during the period commencing from 25/9/2007 to 14/7/2009. That is the claim of HRA respectively oblique read petitioner. As regard the person placed at serial number 15, there is some difficulty so far we are concerned. As regard the person number placed at serial number 15, it appears that the person was wrongly granted HRA on 5/1/09 with effect from January 2008 without certification of DGM, Deputy General Manager, DGM. Accordingly, the steps for recovery of HRA paid to him is being contemplated. Thus, an overall reading of the verification report would go to show that HRA paid to were paid to 14 such persons for different reasons, having no nexus oblique bearing with the entitlement of draw to HRA by the respondent read petitioner and the contrary vacancy position type 4 quarters as indicated earlier. So we have annexed that later. Now, another aspect of this case is that your lordship made an observation that to the effect that we have not failed to state that there was any vacancy or quarter. But in our written statement that we have stated so, that written statement is at paragraph 11, but that was not also not pointed out. Please step on the order.
Lord will find in the written statement, page 53 to 65 of the writ petition.
Yes, who is appearing for the respondent?
Worship, my senior is appearing, worship, he's in next in court number.
But now we are about to dictate the order.
I understand that.
See, the HRA, they have paid already,
Yes, yes.
right?
Worship.
So what Mr. Dasgupta is saying that the two grounds on which the petition was allowed,
Worship.
both of them, if the correct materials available on record would have been placed, then there was a possibility that these two grounds would not have been the basis for the order. So since the HRA has already been paid, we will hear the writ petition again and see. In the meantime, that amount paid shall not be disturbed without the leave of the court. We'll make that.
There is an order passed by lordship that the payment that will be made to the review petition, I mean, the employee shall be subject to outcome of this review petition. That is the order passed by lordship perhaps on 31/2019. That is the first order while issuing notice.
So we'll post WPC 2576/2016 for hearing
Appreciate.
before the appropriate bench. That's it. And we'll clarify that the amount of HRA, how much
Yes,
is the amount? What is the amount?
Exactly. Amount. 1 to 1.5 lakhs or 2 lakhs, between 1 to 2 lakhs, something will be like that.
Enjoy the money in the meantime. And be ready to cough it up if you fail. Yes, that's why the review. All right. Now we take them. Heard Mr. A. Dasgupta, Learned Senior Counsel, assisted by Mr. S. Chakraborty, Learned Counsel appearing for the review petitioners stroke NF Railways authorities. Also heard Mr.
A. Chakraborty.
A. Chakraborty, Learned Counsel appearing for the respondent. Full stop. By filing this review petition, the petitioners are seeking review and or recall of the judgment and order dated 21/5/2018 passed by this court in WPC number 2576/2016, allowing the writ petition filed by the respondent with a direction respondent stroke writ petitioner with a direction that the authorities would pay him the HRA for the period from 25/9/2007 till 13/7/2009, which was arbitrarily rejected by the authorities. Full stop. The judgment dated 25/5/2018 was passed primarily on two grounds. Firstly, that the learned counsel for the railway authorities could not demonstrate before this court that vacant quarters of type 4 category, type Roman 4 category were available during the said period so as to deny the claim of the writ petitioner. Full stop. Secondly, it was observed that by communication dated 23/3/2011, 15 officers enjoying identical pay scales were permitted to draw HRA for the same period, although they were also entitled to type 4 quarters. Full stop. The above fact, in the opinion of this court, was sufficient proof of the fact that either no vacant quarter of type 4 category was available at the relevant period of time, or similarly situated officers were given the benefit of HRA while denying the same to the writ petitioner. When this review petition was admitted, this court had passed order dated 30/301/2019 inter alia, providing that the railway authorities would make payment of the amount of HRA due and payable to the petitioner, which would, however, be subject to further orders that may be passed in this review petition. Today, when the matter is called up, Mr. Dasgupta, learned senior counsel for the review petitioners, has submitted that the railway authorities have paid the HRA amount to the petitioner in terms of the order dated 31/2019. It is also the submission of Mr. Dasgupta that although answer to both the issues raised in this writ petition were available, on the basis of materials existing on record, yet the learned counsel appearing for the NF Railway authorities had failed to point out the same before this court. Mr. Dasgupta submits that there is explanation as to whether the 15 officers were allowed to draw HRA, and that is on account of the fact that they belong to a separate division of the NF Railway. Namely, what is it? Construction.
NFL construction.
Namely, construction line of railway and hence
824.
were governed by a separate set of norms. Full stop.
No, norms is same. Administration is defined.
And
Administration.
therefore were under a different administration who
And that
was not a party to the
Yes.
writ proceeding. Full stop.
these information were not available.
Mr. Dasgupta
No,
further-
this information was not available at that point of time,
It came subsequently.
subsequently.
not implicated as a party to this proceeding, as a result of which the correct information could not be placed before this court. Mr. Dasgupta has further argued that there are materials to show that vacant quarters were in the type 4 category were in fact available during the relevant period of time. And therefore, the said aspect of the matter ought to have been placed before this court. Full stop. On such count, it is submitted that an error apparent has occurred in the judgment dated so and so, which calls for rectification. Full stop. Mr. Chakravarti, learned counsel for the respondent, has opposed the prayer by submitting that failure to point out relevant materials to the court at the time of hearing cannot be a ground to review an order. Full stop. It is no doubt correct that from the grounds taken in the review petition, we find that there was some lapse on the part of the respondents, review petitioners and their counsel. Full stop. However, considering the fact that the issue raised by the petitioner's counsel has a financial bearing on a public entity, and in view of the materials placed before us in this review petition, we are of the opinion that for ends of justice, the matter deserves to be revisited without, however, permitting the authorities to disturb the house rent allowance already paid to the petitioner on the strength of order dated 31/2019, unless otherwise directed, full stop. In other words, we are convinced that the impugned judgment dated so and so deserves to be revisited on the grounds noted herein above. As such, the order is hereby recalled. The registry to list WPC number 25, registry to restore WPC number 2576 of 2016 to its original file and list the matter before appropriate bench.
But the payments have already been released.
Yes, those will not be disturbed unless otherwise directed. So you get something, they get something. You get the money, they get the review order. What else could be a more happy ending?
Win-win situation.
See, the judiciary nowadays is really thinking of win-win situation, huh?